Homeland Security has made it abundantly clear that enforcement of immigration laws against individuals unlawfully residing here in the U.S. will be amongst its top priorities. Pero may mga pagbabago po sa laws in terms of removal proceedings. Alamin po natin yan at ang mga detalye ngayong hapon sa ating American Dream.
This American Dream segment is brought to you by Aquino & Lowe Law Firm, answering your immigration questions.
Joining us on the phone ang ating kababayan kompanyera. Magandang hapon sa iyo, Attorney Allison Aquino.
Good afternoon, Janelle.
Allison, let's talk about this new, I think we briefly touched on this last Monday in the news, but can you explain to us further what's the implication of these new rules regarding removal proceedings?
Yes, the head of the Immigration Customs Enforcement Unit issued a policy memorandum just last August 20th, which essentially tries to make it easier for the courts and for the immigrants as they go through the removal process. Because there have been so many removal cases that have been started in recent years, it's just completely flooded the court system. And so ICE trial attorneys, they have recognized that a lot of the cases that are before the immigration courts really shouldn't be there, that some of those cases should actually be returned back to the Immigration Service just for regular processing rather than proceeding through the courts.
Are you talking about those that are here maybe illegally but are awaiting pending petitions?
Well, the new memo pretty much pertains to individuals who are here in the United States, and it applies to individuals that either have approved petitions or have petitions pending with the Immigration Service that would allow them to immediately apply for the green card.
So essentially, Allison, this is good news for our kababayans.
It is good news because a lot of people, they're very scared whenever they're in front of a judge, and the fear of being in front of an immigration judge for removal proceedings, that can be a very terrible experience.
Right.
And so this memo essentially recognizes that a lot of those individuals really don't need to be put in that situation. Immigration still wants to enforce the laws, but they recognize that rather than being in front of a judge, a lot of these individuals should actually be returned back to the regular Immigration Service and their cases just processed as if they were never in court.
And for those of us who are not familiar, can you explain to us what happens during a removal proceeding, or what happens like when you're arrested for illegally staying here? Are you detained, and then when you go through a removal proceeding, as soon as the judge mandates or makes a decision, do you immediately get to go back to where you're from, in our case, to the Philippines?
No. As far as how the process works, removal proceedings are always initiated by the issuance of a document called Notice to Appear. On that Notice to Appear, the individual is typically just served that Notice to Appear via the mail, rather than immigration coming and knocking on the door and actually detaining an individual. In rare circumstances, such as if an individual has a criminal past, then immigration will actually come and detain the individual and then issue that Notice to Appear. But the majority of individuals who have just simply overstayed their visas, they simply get this Notice to Appear in the mail, advising them that removal proceedings have been started against them, and it instructs them to appear in front of the judge for the removal case.
Okay.
As far as actually being deported or the removal proceedings themselves, it's certainly not a quick process. Every individual is entitled to due process under the law, and so no individual is simply brought in front of the judge and then ordered deported and then sent back to the Philippines.
Okay, so most definitely this memo is going to be welcomed by our kababayans. How do we accomplish the merits of the memo?
Well, as far as taking advantage of the memo, essentially individuals who have an application pending in front of the Immigration Service, those applications will now be expedited by the Immigration Service, so that cases that have, for example, many cases have dragged on for several years simply because the immigration has been backlogged in the processing of, say, an I-130 petition by a U.S. citizen spouse on behalf of the individual. Under this memo, those type of cases should no longer take several years. Those cases will be expedited because individuals such as in that case where the person is married to a U.S. citizen, that individual should be entitled to a green card. And so rather than spending several years and wasting the resources of the court, those type of cases will now be expedited. Perhaps the removal case itself might be terminated so that the individual can simply process the green card before the Immigration Service rather than consuming the court's time and, of course, the fear of going in front of the immigration judge.
Okay. Well, thank you so much for sharing that good news to us this afternoon.
Thank you for the opportunity, Janelle.
And more power to you, Attorney Alison Aquino.
Bye-bye.
If you have any questions about immigration, we were flashing you. That's the number on the screen. Rather, they do give free office consultation, or you may check out their website, www.aquinololaw.net. Magbabalik pa po ang Kababayan LA. Don't go away.